Good morning and welcome to Trusaic's California's new pay data reporting law and what you need to know before you file workshop. Attendees will be in listen-only mode throughout the workshop, but you are encouraged to submit questions at any time by selecting the Questions tab at the bottom of your Zoom window and typing in your questions and clicking Send. A follow-up email will be sent after today's presentation. Our speaker today will be Mark Dwyer, who is our Vice President of Data Science and a pay equity expert. Mark has over 16 years of experience in statistical analysis within class action litigation and has offered oral and written testimony regarding statistical modeling. Mark earned a PhD in economics from the University of Rochester, an MA in finance from the Wharton School, and a BA in physics from the University of Pennsylvania. He is a member of the American Economic Association and the Econometric Society. And with that, I'll turn it over to Mark.
Great, thanks, Matt. Welcome again, everyone. Following this observation by our CEO, Robert Sheen, on behalf of Trusaic, we've been working very hard to ensure that you get the most out of this workshop on pay data reporting. At the highest level, we'll discuss the following 4 areas related to this new California filing requirement. First, what do we mean by pay gaps and why are those relevant to pay data reporting? We'll also look at submission details of SB 973. We're reviewing pay gaps because SB 973 in particular is meant to promote voluntary compliance with equal pay and anti-discrimination laws, and to more efficiently identify wage patterns and allow for effective enforcement of equal pay or anti-discrimination laws when appropriate. The Department of Fair Employment and Housing, I'll abbreviate that as DFEH because it's kind of a mouthful. It enforces prohibitions on pay discrimination under the California Fair Employment and Housing Act and the California Equal Pay Act. Okay, so we'll be covering submission deadlines, the implications of submitting these data, and how pay equity audits can help to mitigate some of those issues that arise from submitting these data. Next slide, please. Okay, so I'll begin with talking just briefly about what are gender pay gaps. First, what do we mean by that, right? Well, it can mean many things. But in general, it's a measure of the pay differences between men and women, or between genders more generally, across an organization or society. They can be examined in a number of ways, such as in terms of mean differences or median differences, and either controlling or not controlling for other effects on wages. They're often displayed as a share of a dollar, so cents on the dollar, like 80 cents on the dollar. Women earn 80 cents on the dollar of a male dollar, that kind of statistic. And typically for gender pay gaps, there's been a lot more work done on male versus female and much less done on non-binary gender pay gaps. The societal gender pay gap is the first problem that the California pay data reporting requirement is responding to. At least in theory, pay differences based on sex have been federally prescribed since the passage of the 1963 Equal Pay Act. For employers, the gender pay gap usually takes the form of comparing average hourly wages for workers of different sexes. Pay gaps can be measured, as I mentioned a moment ago, as a simple average wage difference that does not control for differences in skill, effort, and responsibility, or they can be measured after controlling for these legitimate factors that affect pay differences. Within an organization, conducting a pay equity audit measures gender pay gaps this second way, after controlling for legitimate pay factor differences. Unlike the societal gaps, at the organizational level, when conducting a pay equity audit, gender pay gaps are often eliminated or reversed in some cases after legitimate pay factors are taken into account. At a societal level, in contrast, when controlling for various measures of these legitimate factors driving pay differences, women still earn less on average than men do. Next slide, please. And as an example, these results here control for education attainment. For looking at the gender gap between men and women, men in blue and women in gray. While it is expected that workers with more education will on average earn more, and in fact they do in this graph as we go down, workers with more education earn more. Within the same education level, women earn less on average than men do. These gender pay gaps range from about 80 cents per male dollar earned for workers without a high school degree to only 74 cents per dollar per male dollar earned for workers with college or more advanced degrees. So contrary to what one might expect, this shows that the gender pay gap actually is worsening with higher levels of education. Both men and women show higher earnings at higher education levels, but men start from a higher base for the least educated level and enjoy larger wage increases for each step up in education level. Next slide, please. So from there, we're going to move on to another dimension of pay gap, which is the racial pay gap. It's defined similarly to the gender pay gap as the difference in average hourly wages between workers, but of different races or ethnicities. As this quote indicates, at least some of these societal racial pay gaps have been worsening over the last 20 years. Like the gender pay gap, the racial pay gap can be measured before or after controlling for legitimate drivers of pay differences. At the organizational level, again, a pay equity audit measures racial pay gaps after controlling for legitimate pay differences. No less significant, the societal racial pay gap is the second problem that the California pay data reporting is responding to. Also at an organizational level, in contrast to the societal level, racial pay gaps can often be resolved, just like with gender pay gaps, or reversed after controlling for legitimate pay differences. Again, though, from many perspectives, there is a persistent societal wage gap across different races and ethnicities, even after controlling for such legitimate pay differences. As an example, let's go to our next slide. This is, again, looking at this educational breakdown, where we see on average, white workers are paid more than Black and Hispanic workers at almost every educational level. So again, this is from a societal perspective, this chart views the racial pay gap for workers with the same level of education. It reveals that white workers are paid more than Black and Hispanic workers at virtually every level of educational attainment. As with men versus women, wages increase with additional education, but those wage increases are larger for whites than they are for Blacks and Hispanics. And I've just put in a plug here that there's been an extensive report on race in the workplace released by McKinsey that delves into this in greater detail. So that's a brief look at the racial pay gap and the gender pay gap. Let's go to the next slide, please. Okay, so as you might expect, these are not best analyzed in isolation. There is an interaction between the two, and that will show up often for women of color. So here's some statistics put together from the National Women's Law Center. At the intersection of gender and racial pay gaps, women of color are affected by both forms of pay discrimination. These statistics show substantial differences in annual median earnings, so suggesting substantial losses in annual earnings, as you can see here. That's what these are being portrayed here. In terms of cents on the dollar statistics, like we've been talking about, these translate into 63 cents per white male dollar for Black women, 55 cents per white male dollar for Latinas, 60 cents per white male dollar for Native American women, and 87 cents per white male dollar for Asian women. So you can see that these two factors have to be really considered in tandem and not in isolation. Next slide, please. So with all this data and statistics and analyses showing both a racial and a gender pay gap and an interaction between the two of them, there have been numerous states have been moving to augment existing federal anti-discrimination statutes. In particular, many states are passing pay transparency laws protecting employees who share information from retaliation. This is one of the key provisions of the California Fair Pay Act, which became law in 2016. Another pay regulation trend affecting California and many other states is a prohibition on using or asking about a job candidate's prior salary for salary determinations. California's state legislature first passed pay data reporting in 2007, but it was vetoed by the governor at that time, Governor Jerry Brown. SB 973 was a resurrection of that, and it was again passed by the legislature in 2020 and then signed into law by Governor Newsom. California is often the leader in employment regulations, so it's reasonable to expect pay data reporting to be required in additional states in the future. Further, this SB 973 was modeled on the EEO1 component 2 pay data reporting requirement. And there's every indication that that will be coming back, although we don't know exactly when. That's been under study with the National Academy of Science right now. But the key takeaway here is that SB 973 is not the exception, but exemplifies a trend toward greater scrutiny of compensation that all employers are facing as time progresses. Next slide, please. So in particular, what's in the California Fair Pay Act, because we are talking about, after all, reporting for California. This became effective in 2016 and bolstered existing sex discrimination laws, expanding them to cover race, ethnicity, and ethnicity as well. It encourages pay transparency by protecting workers discussing their wages. And it broadens the definition of comparable jobs to be substantially similar jobs. So jobs need not be identical, but can be substantially similar. And that similarity, substantial similarity, is based on these criteria of skill, common skill, effort, responsibility, and working conditions. Those four elements will be important for us to, we'll be coming back to those a little bit later. It also prohibits the use of prior salary to justify pay differences. These four elements, though, skill, effort, responsibility, and working conditions, can be reflected through seniority, through merit, through other bona fide factors other than sex, race, or ethnicity. A bona fide factor, in a nutshell, means something that reflects business necessity, capturing those four elements. As we'll see shortly, SB 973, this reporting requirement, provides little scope for explaining these differences in the four elements, even though they would go a long way in explaining differences by gender and race, ethnicity. So, but I'll come back to that shortly. Next slide, please. Okay, so that's just a real quick rundown that I wanted to get through on sort of the background, what are pay gaps, and what's the legislation that's behind SB 973, what's being enforced there. But before I move on, Matt, do we have any questions on these background issues?
Yes, Mark, we have a couple of questions. First question is, how much of the gender pay gap do you think comes from not asking for more money? One participant mentioned a hacking HR session on mentoring women yesterday that brought up that women are less likely to feel they are experts. Do you have an opinion regarding how much of the gender pay gap comes from not asking for more?
It's a great question, Matt, and I've seen that issue is actually in federal legislation. Training women to be more assertive, but there's also a fair amount of empirical evidence that pushes back against that says that's not really the issue. There are gender stereotypes that are also at work, that when women are more assertive, they get punished for it because of environmental attributes in the workforce and attitudes. So it's not the case that women are intrinsically, much of this evidence suggests that women are not intrinsically less able to ask for raises than men, but they're punished more for doing so.
Okay, and the next question, does the pay disparity data take into consideration years of experience and location differences?
So the data that's being reported under SB 973 does account for differences in establishments. So it does take that into account. It does not account for years of experience. So that's why we're saying that many of the legitimate drivers, such as seniority, that would be are legitimate for distinguishing different pay levels, are not reflected in the submissions under SB 973. But establishment, so locate and thereby location, is captured.
Okay, we have other questions, Mark, but I think they'll get answered in the next section. So
great. Okay, thanks, Matt. Let's move on then to the next slide, please. Okay, so we're going to start talking about details of SB 973. Maybe the most important deadline detail is the deadline, which is in 19 days. So the Department of Fair Employment and Housing, again, DFEH, is charged with enforcing and collecting these submissions. The deadline is March 31st. So that's right around the corner, but there is a deferral mechanism that DFEH offers on their website that will provide a 30-day extension if it's granted. The website is the only means by which deferrals can be submitted and will be considered. And it provides 3 options for why a deferral might be needed: lost records due to a natural disaster, severe economic hardship, or that the reporting requires infrastructure or technology changes. Any deferral request has to be made prior to March 31st. Separate deferrals have to be made for each employer identification number, either federal, if you have multiple employer identification numbers. Trusaic has been assisting clients with both SB 973 filings and deferral requests. To date, deferrals seem to take about 3 business days to get a reply from DFEH, and so far we have not had any deferral requests denied. They've all been granted. So next slide, please. So that's about when, so we just covered when the data is due to be reported and what flexibility there is there. Which employers are covered? Okay, that's the key question. So the answer is private employers with 100 or more US employees who are also required to file an annual EEO-1 report with the EEOC and have at least 1 employee in California. Okay. Similarly, if you are an employer in that category, which employees are you required to report to California? Well, all California employees, whether they're working within California or reporting to a California establishment, i.e. location, they all need to be included in the report. So EEO-1 reports are required of most private employers with 100 employees in the US. That same nationwide requirement applies to SB 973. Do you have 100, as an employer, do you have 100 employees within the US? So what are some examples of employers that may not have to file under SB 973? So an employer with no employees in California, regardless of size, does not have to file under this requirement. Nor do employers that are different types of organizations, such as schools or colleges, who are filing alternatives to the EEO-1 report with the EEOC. So we'll look at one of the key provisions here, though, is what does it mean to have an employee in California? We'll look at that in greater detail. Next slide, please. So a little bit more on counting that to meet whether that threshold is met, right, is which employees count. So all employees in the US are included, whether they're full-time or part-time, and whether they're on paid or unpaid leave. So long as they're considered an employee, they're counted towards the 100 for that threshold showing. Okay, the next slide, please. Okay, what about temporary staff? Yes, in general, the default is yes, temporary staff are part of that head count. So it depends on, the DFEH gives a definition of employee. It's defined as an individual on an employer's payroll whom the employer is required to include in an EEO-1 report and for whom the employer withholds federal Social Security taxes from their wages. So that's the definition of an employee for counting this for this 100 employee counting requirement. Next slide, please. Okay. Then in even greater detail, when do you take a measurement to see whether you have 100 employees or not? All right. So the default is a snapshot period, which was the last quarter of 2020 for this reporting year. So if you have 100 employees within a pay period there, typically you're going to be required, if you meet the other conditions, to file under SB 973. So there is this other option, which is this notion of regularly employing 100 employees. So even though, and that's really a seasonal issue. So if during a business's regular season, the employer had more than 100 employees or 100 or more employees, then that constitutes regularly employed employees, being at least 100. So for instance, suppose you have a business season in the summer, right? But then everything shuts down in October through December. What the DFEH is looking at is how many you're employing in the summer, not how many you're employing during the snapshot period. So it's basically you have to pass both of these tests, that you didn't regularly employ for some seasonal component 100 employees, and that you don't have any pay periods within the snapshot period where you are employing 100 employees. Now, I would say that they're not being completely draconian about this. If an employer just happened to have a pay period during the last quarter in which their number of employees just happened to exceed 100 employees, but in general they're below that threshold, then that does not automatically trigger the reporting requirement. I would say, though, that it's most likely that if you're in that boat, then you probably didn't have to file an EEO1 report either, unless you're a smaller federal contractor. All right, next slide, please. Okay, another dimension of counting employees, in addition to when you count them, is what counts as an employer. Okay, so this is, and here, the California is following the same standard that the EEOC does in their EEO1 reporting, which is the enterprise test. So distinct employers that share ownership, control, or management are treated as a single enterprise in terms of counting employees. All right, next slide, please. So here are a couple of examples now about some scenarios. So as a question, example number one, if an employer has virtually all their workforce, 99 employees in Texas, and one employee is teleworking from California during the reporting year, is that employer required to submit? And the answer is yes, because you have an employee who's working in California. Even if it's due to COVID and everybody's working remotely, and this employee decided to go back to family members or so on to work remotely, that counts as a Californian employee, and you are required to file under this law. Next slide, please. Okay, so here's an example where an employer in California has 100 employees, but 30 of them are always working outside the state. They're working at client sites. Does that employer need to report? And the answer is, again, yes. You must include the employees assigned to California establishments. So even these are employees, they're employed by the California establishment, but they're working outside the state, they count. All right. So in this case, an employer would have to file a report. And the second question is whether or not these 30 employees would be included, and they would be included in the actual filing. Okay, so their characteristics would be included in the actual filing. All right, because they're reporting to a California establishment. Next slide, please. So what is the reporting time frame? So we touched on the second bullet point here, the snapshot period being that last quarter of 2020. The reporting time frame, which is important to keep in mind, is that you in the snapshot period, you identify which employees you're reporting on. Okay, but the reporting time frame that you're reporting about them is the whole of the reporting year, the whole of the calendar year. So it's for their whole pay and their whole hours worked for 2020. All right. So an employee taking time off during the snapshot period, like we already saw, people on PTO or other time off, still need to be reported in terms of their annual pay and hours worked. Okay, next slide, please. All right, so what has to be reported? So we know who has to report. We know basically which employees have to be reported. What has to be reported about them? So for each included employee, the report reflects 5 elements. Their establishment, okay, where they worked or where they report to, their job category, they're using 10 federal job categories, their gender and race ethnicity, their annual pay with a specific measure being used there, and their annual hours worked. So if you've been filing EEO1 reports, then the first 3 bullets on this slide are quite familiar, but we'll turn to each of these elements briefly in the next slides. Next slide, please. So first, the notion of an establishment. So for this reporting, your establishment is the same as that for EEO1 reporting, namely a single physical location where business is conducted or where services or industrial operations are performed. Later, California anticipates moving to a more abstract definition of an economic unit producing goods or services. So, if you are an employer with multiple establishments, you'll be submitting a single report containing all of your establishment level data. It must include all employees in or out of California reporting to California establishments, and all California employees reporting to non-California establishments. So the second clause is that if you're like we saw in that example, if you're reporting to Texas but you're working in California, you're included in the report as well. Next slide, please. So we've already talked somewhat about remote employees, but let's just hammer that again a little bit. So, and this is particularly relevant because so much of the workforce has been remote, these working from home this past year. We know that employees working remotely from California need to be reported, and we know that employees working remotely outside of California, but reporting to a California establishment need to be reported. The question here is, under what establishment should those remote workers be reported as being part of? Because one of the things that's being submitted is the establishment for each employee. So each employee is assigned to one establishment. They're not apportioned in any way. So you've got to make up your mind and put them in a particular establishment. No half employees or double counting. The DFEH provides 3 options for the establishment under which to count the remote employee. Where they reported to during the snapshot period is an option. Maybe the first option. Where they reported to for the majority of their work is the second option, and the default, if neither of those apply, is to the headquarters of in a multi-establishment context. Okay, next slide, please. So we just said that one of the after establishment, the next piece of data that's being submitted and aggregated in terms of these submissions is job classifications. What job category do workers fall into? These job categories are familiar from EEO-1 reporting, but they take on greater significance in the context of pay data reporting. This gets back to the question that Matt asked earlier about seniority, because seniority is not included here. It's just these 10 categories. These are the only measures submitted of data that reflect differences in the 4 legitimate business factors affecting pay differences: the skill, effort, responsibility, and working conditions that were highlighted earlier. It's probably worth reviewing employee assignments in these categories for accuracy, even if assignments have already been made for EEO-1 reporting purposes, because now that those categories are going to be used to make pay comparisons. Next slide, please. Okay, so we've covered establishments, we've covered job categories. The next aspect being reported is gender and race ethnicity. All right, so you see here 21, a list of the 21 categories. And the reason why that's an expansion relative to EEO-1 is because California recognizes a non-binary gender, a third non-binary gender. It uses the same race ethnicity categories as the EEO-1 report. So how is gender to be determined? Employee self-identification is the preferred method of identifying sex information. Did not state is not an option. Employers have to make an assessment and have to categorize into one of these 21 categories. And this is a quote from the DFEH. If an employee declines to state their sex, employers must still report the employee according to one of the 3 sex categories using current employment records or other reliable records or information, such as an employee's own preferred pronoun. In terms of race ethnicity, again, self-identification is the preferred method. Again, if an employee declines to state race ethnicity, employers must still report the employee's race ethnicity according to one of the 7 race ethnicity categories. Here again, current employment records, other reliable records or information, or the observer's perception is the last option. But again, an assignment has to be made. Next slide, please. All right, so we've covered, we're getting through our list of 5 here. Now we're up to pay bands. So how is pay reported? The actual annual pay is not being reported, but it's being reported as with respect to which pay band an employee falls into, annual pay bands. These are used by the Bureau of Labor, used by the U.S. Bureau of Labor Statistics. There are 12 annual pay bands. They run from under $19,239 a year to over $208,000 a year. And the first thing that strikes me is that these are relatively broad pay bands. So someone would be reported as being in pay band 6 if they're making between $49,920 and $62,919. The top of each of these pay bands differs from the bottom of the pay band by about 25%. So these are broad, they're broad pay bands, and they're only approximating actual pay. And they raise the question as to what kinds of pay gaps they can detect. For example, suppose male and female workers in the same position, same location, have a pay difference of 15%. Just suppose there's just flat out discrimination, okay? Since these pay bands are broader than this, that 15% gender pay difference may not be detectable in the submitted data. Given that these data are only likely to detect relatively large pay differences, it's important for employers to know whether such pay gaps exist in their data. So we'll come back to this in a few slides when we talk about what the reported data may reveal about your organization. Next slide, please. So what's the measure of annual earnings? It's coming from the W-2. The W-2 is also used for component 2 reporting, but it's box 5, not box 1. And it includes 401 and 403B retirement contributions. So just a heads up that it's not the headline box 1, but it's actually box 5, a broader notion of income, annual income. Next slide, please. Okay, so we've talked about pay, we've talked about the demographic issue, data, the location data, and the job categories. The last piece is about how hours are measured. Okay, so for non-exempt employees using timesheets or other records to calculate hours worked plus any form of time off. That's a difference from the federal reporting requirements under EEO1 component 2 that you may be familiar with, that here paid time off does count towards total hours. All right, and it's actual hours, not annualized in any kind of way. So it's not, even if an employee was hired in the last few months, it's just the hours that they worked for those few months, that's not being expanded out over the course of a year. It's worth noting here that while the number of employees in a pay band effectively reflect the pay data that's being reported, in other words, the pay data will say that we have 10 employees in pay band 6, for example. It's their total hours that make up the hours data being reported. So for example, if we have 5 employees all working full-time 2080 hours last year, and they're all in the same category of establishment, job category, gender, race, ethnicity, and pay band. Okay, so they would be grouped together in terms of a count. There'd be 5 within a pay band. The hours entered would actually be 5 times 2080 or 10,400. Sorry, 10,400 for those workers. All right, so now that we've covered who has to file, which employees have to be filed, and what has to be filed, let's take a look at how the data is filed. Next slide, please. Okay, so this is actually coming from the template that the DFEH provides, and it's apologize that it's kind of wide and a little bit hard to read, but there's a section 2 which has the detailed data, and there are 2 sides to it, the left side and the right side. This is the left side, the establishment and employer information. Prior to this, in the same spreadsheet, okay, above these rows in the spreadsheet is another section with more general information about the employer, such as detailed information about their registration with the Employment Development Department, okay, which is another California agency that everybody should be familiar with who has any presence here in California. It also offers a place for specifying federal and state employer identification numbers, who the parent company is, and any affiliated companies. With this slide, we're taking a quick look at the left side of the spreadsheet of the SB 973 detail filing. And you can see that essentially what's being identified here is differences in establishments. Different sets of rows correspond to different establishments. We have 3 different establishments identified here, all part of the same enterprise. And then on the right-hand side, you can see that the headquarters is identified. Okay. And then some characteristics. And then the other piece that's being reported here is what the total number of employees are at each of these establishments. And that's in column J here. All right. So let's go to the next slide, please, and take a look at the other half of this spreadsheet. So here we're looking at section 2B, which is the employee level data. And so you can see here that we've got these, so a set of rows here corresponds to a given establishment, and then within that, that's broken down by job category, then within that by race, ethnicity, and sex, and then by pay bands, and then finally we have the employee counts and the total number of hours. So you can see that the total number of hours are relatively large numbers. They're not counts, they're multiplications of total hours worked. All right, and at the last, I don't want to miss that in the last side, on the right side of this, we also have a row for clarifying remarks. So it's important, we'll come back to that issue and how that might be used or not used a little bit later. All right, next slide, please. Okay, so Where is this information submitted? It's submitted through the DFEH portal on their website. The DFEH gives you a couple of options. You can submit it as a comma separated file or a Excel file. There's even a fillable online form, but it'd probably be better to have a record of what you've submitted before you submit it. DFEH also has extensive guidance on its portal, along with frequently asked questions and templates. And so the website there is dfeh.ca.gov, pay data reporting. Before turning to issues of enforcement and confidentiality and mitigation of the implications of reporting, Matt, have we received any questions regarding the mechanics of SB 973 filings?
Mark, there's been several questions from the audience, a number of different categories. One question, if an employee doesn't report their ethnic information, should an employer guess their ethnicity through visual observation?
Yes, that's the last resort. Yes, that an employer takes their best guess and follows that route.
Okay, a similar question. One participant says we have only 19 days left to capture non-binary information for employees that we have nowhere in our system to capture. We use ADP and it's set up using the EO1 categories for gender, race, and ethnicity. What should we do?
So this may be something that requires some legal input, but one of the sources of information for identifying sex is payroll data. So that's a legitimate means for identifying sex as it is right now. To the extent that you have employees who have a self-identified as non-binary and the employer is aware of that, then that needs to be, then those submissions would need to reflect that information. But if employees have not self-identified as non-binary and you have records that we were just discussing that indicate a sex for them, I think that the guidance would be that you're relying on admissible materials for determining sex for the submission.
Thanks, Mark. And there are several questions seeking clarification regarding when an employer needs to report. One participant asked, when reporting, are you allowed to exclude non-California employees when filing if just a few are located in California versus everywhere else in the United States?
You're not allowed. No, as our example showed, if the employees are located in California, then they are considered California employees. So for example, the employment development department requires everybody be registered with them, even if they're self-employed. Yeah, those would be considered California employees and would be subject to this reporting requirement.
Okay, and this can get really confusing. So just probably a few more questions along the same lines. If a business has more than 100 employees in the United States, but less than 100 in California, do they only need to report the California employees?
They may report more than that, but yes, they only need to, well, let's see, they need to report California employees that are doing work in California, and it depends on the employees outside of California. Are they reporting to California establishments? So if they're reporting to California establishments, they need to be included in the report as well.
Okay, another participant asks, so if we had 200 employees in the United States, but only 8 in California, do we report for all employees or just the 8 in California?
The minimum reporting requirement includes the 8 that are located in California and any employees outside California that are reporting to anybody. Suppose one of those California employees is a manager and manages 3 or 4 people that are outside California. They have to be included as well.
Okay, and if, let's say a company had 5 sales employees in California reporting to their establishment in Washington, do they only need to report the 5 California employees?
That's correct. If that's the the complete scenario is that those 5 employees are the only ones that are in California and no one else is reporting to California, then that's true. They may report they also may include a report that includes the other employees for the establishments to which those 5 employees report, but they are only required to report on those 5 employees.
Okay, what if they don't have any offices in California, but they have, let's say, 15 remote workers who live in California? Do they have to report them?
According to the DFEH, that yes, they do. So long as they meet the EEO1 reporting requirements and the 100 count threshold nationally, yes.
Okay, what if there's no brick and mortar building? The entire workforce, including the headquarters, is virtual.
Right. I mean, that's a great that's a great question. With a completely virtual workforce, again, you might need to get a second opinion on this, but there is some location for the establishment. So, for instance, if you're an S corp and your the CEO, the president of the company is working out of their home, right? That counts as essentially the headquarters, and so all the employees would be essentially considered to be reporting to that establishment. So for those employees who are doing that work in California would be covered and by the submission requirement, and they would be reported as essentially reporting. They've got to report somewhere. They can't report nowhere, so they would be reporting to either an intermediary location if there's some depth to the organization, or virtual depth, which might be another home for another manager or director in the business, or it would be to where the president of the company is.
Okay, Mark, and there's some questions about seasonal employees. So if you had 150 seasonal staff, let's say for the summer, but only 60 employees who work year round full time, does the employer have to report?
Yes, that would fall under the notion of regularly hiring, regularly employing 100 employees. You're above the 100 employee threshold for the season for which you're busy, and so that would count as meeting the 100 employee threshold.
Okay, Mark, and some industries were closed due to COVID for the snapshot period from March even till now. Do they need to complete this for March reporting deadline?
So the probably the relevant criteria there are do you have employees on your payroll? Do they meet the definitions that were they being paid? You would be withholding Social Security for them, and if you were required to file an EE1 report, you would include them in that report. And then they are on effectively paid or unpaid time off, so they're still on your payroll technically, unless they've been let go, right? So if they would still be counted towards your 100 employee count, and so you would still be required to file a report.
Okay. There's some questions about subsidiary companies, Mark, all of them having different EINs. Can they be submitted together, or do they have to submit them separately as the parent company?
So what I've seen in reviewing the documents is that submissions you're required to submit all of the affiliated EINs, including the parent EIN, on the submission form, and that. So I think there's a little bit of uncertainty on my part on this, but it looks to me like all establishments for an enterprise should be submitted on one form. The one caveat to that is that in our experience, when we ask for deferrals, we have to do that by separate EIN. So that seems a little bit inconsistent with the fact that all the establishments are being pulled together on a single submission, and all the EINs are being listed on the same submission. But yeah, so I think there might be a little bit of ambiguity on that issue. But it certainly is the case that all affiliated and parent EINs are listed on the submission, and all establishments are meant to be listed on the single submission.
Okay, Mark, and there was a few questions related to EEO1 reporting. So since the EO report was not required to be submitted last year, will it be a red flag that column L will reflect no?
Yeah, I haven't had any conversations with people at DFEH as to whether or not they're looking at that as a red flag or not. I think they're aware, particularly because they've been offering this deferral process at the very least, that last year had some exceptional circumstances. So I'm not sure that field would be given a lot of weight this year.
Okay, and last one here, Mark, we'll let you get back to your presentation. One attendee asks, am I correct in putting the address of the office the employee is assigned to, not their home office, in the body of the spreadsheet?
That's correct. I assume the questioner is asking about that they're working remotely, so they're. I think that might be interpretation of. There are two interpretations of home office, but I'm interpreting that to mean not their home as an office. That's right. The establishment that you would put is where they're reporting to if they're working remotely.
Okay, thanks, Mark.
Okay, great. So let's move on to our next slide, please. Right. So, what are the enforcement mechanisms? And I've talked about this a little bit here. So, the annual pay data reporting is implemented and enforced by DFEH. DFEH may seek an order to compel an employer to comply and is entitled to costs associated with seeking the order for compliance. There's a key linkage here in terms of what you're submitting and the enforcement mechanism. DFEH seems to indicate that the primary tool that they'll be using to measure compliance with SB 973 is cross-referencing employers with those registered with the California Employment Development Department, or EDD. If an employer is registered with EDD and meets the conditions to be required to file pay data under SB 973, it's probably a good idea to do so, because they're asking everybody who's filed for that information. They're going to be cross-referencing it. They're going to be accessing the EDD database and saying, okay, who are we missing? The EDD publishes guidance on their website as to which employers are required to be registered with them. The threshold payment to an employee for an employer to have to register is $100 or more. Sole proprietorships are required to be registered with the EDD. So it's a pretty broad net there. Okay, next slide, please. Right, so now the next question is, once you've submitted this data, how confidential is it? Well, by law, individually identifiable information in the annual pay data reports is considered confidential and not subject to disclosure. However, DFEH is holding on to this data for at least 10 years and will be publishing and publicize aggregated reports if reasonably calculated to prevent association with any person or business. In addition, DFEH will be sharing the data with the division, more broadly with the Division of Labor Standards Enforcement. That division may use the information in these annual reports as needed upon instituting an investigation or enforcement proceeding under the California Equal Pay Act or the California Labor Code. Regardless of confidentiality, a plaintiff, such as a former employee alleging discrimination, can seek a copy of the annual pay reports from their employer and or potentially subpoena the reports from DFEH. So that data is long-lived, and it's always subject to a subpoena because it's part of a regulatory compliance disclosure. Now that we've covered what's involved in complying with SB 973, I'd like to turn to some of the implications of compliance. So we'll have the next slide, please. So what does DFEH see in your data, and what does your data reveal? Okay, so the data only shows raw pay gaps, and by that we mean that we're only controlling for legitimate differences in pay based on those job categories and based on locations, so differences in cost of living between, say, high cost cities and low cost cities. That would be reflected because you're filing data by establishment. And then the only other dimension to legitimately discriminating between jobs at different pay levels are the 10 job categories. So it's important, and we also saw that SB 973, the data that's submitted, will likely detect pay differences only where workers of different genders or race ethnicities are concentrated in different pay bands within the same job category. So within sales, white workers are in different pay bands than black workers, more predominantly, or something like that. That's what's going to show up in those data. So it's important to know whether such pay gaps are apparent in your submissions. As part of its filing assistance for employers, Trusaic measures those pay gaps implied by the SB 973 filings, what's revealed in those data, both with respect to gender and race ethnicity at the establishment level and the job category level. Trusaic also tests for the statistical significance of those gaps and identifies patterns both across establishments and job categories that may invite additional regulatory scrutiny. For example, within the professionals category, an employer's data may show that male professionals make more on average than non-male professionals at every establishment for a multi-establishment organization. Or alternatively, a gender pay gap may only be evident and be really pronounced at one establishment out of many. So those are both of those signals are something that regulators look at. They want both consistent pay gap patterns and exceptional pay gap patterns raise flags. While a pay gap risk assessment will reveal these issues, such as those performed by Trusaic, it's just a starting point. That's because for uncovering pure pay discrimination, what we know because of these broad job categories and pay levels, that the reported data is a blunt tool at best. In addition to the reporting pay in 12 broad pay bands and the 10 federal job categories as the only identifiers distinguishing workers by measures of skill, effort, and responsibility, the majority of identified pay gaps may be explained by differences in legitimate business factors, but the DFEH doesn't know that to be true in any particular case. They just don't have the data. They're not asking for the data to make those determinations. Further, even if the pay gaps revealed in the reported pay data are due to legitimate differences in factors like seniority or experience and so on, these legitimate factor differences can raise diversity and representation issues, which is also within the DFEH mandate for enforcement. The reported pay data may reveal pay discrimination, or it may be indicative that certain protected groups are underrepresented in the higher paid positions. For example, that men are more heavily represented in higher paid positions may be indicative of a Title VII violation rather than pure pay disparities. Even if systematic differences in training, tenure, or experience explain why men are in higher paid positions, so we don't have a pay discrimination issue, these differences may be the result of discrimination in hiring, advancement, and retention. The DFAH mandate is not limited just to pay discrimination, but includes non-pay forms of employment discrimination as well. This means that the pay data reporting under SB 973 will not be used just for pay discrimination investigations, but also for disparate impact investigations as well. While the SB 973 reporting format offers ample space for additional qualifying remarks, employers need to carefully vet any such remarks for what those remarks might suggest regarding these other non-pay forms of employment discrimination. So just some caution on using those remarks columns. Next slide, please. Okay. So fortunately, there's a real strong, robust tool that will be pretty proactive and preemptive way of assessing what your pay situation is and your representation situation is, and that's a pay equity audit. It identifies pay disparities that are liabilities, not just the raw pay gaps, by determining statistical weights for legitimate business factors and then controlling for those legitimate differences. It identifies systematic differences, though, as well, in job level, seniority, managerial responsibility, et cetera, that may be indicative of policies with disparate impact across genders and race ethnicities. So a pay equity audit will identify evidence of pay discrimination, and it also will give you information about potential anomalies in terms of job qualifications or promotions and so on. The pay equity audit further establishes which of these legitimate business factors are most relevant to explaining the gender and racial pay gaps. So you may see differences in Black and white workers in terms of seniority and in terms of managerial responsibility. And the question is, which of those are really driving pay differences? Okay, that's what a pay equity audit can also should tell you. For example, are there systematic differences in company tenure or in managerial responsibility between Black and white workers? And knowing which of these is most relevant to pay, the pay equity audit will tell you which of those are most relevant to pay differences. Employers can prioritize which policies or procedures to investigate for potential disparity impact on different racial groups of employees. That is, a pay equity audit addresses not just parity in pay, but parity in diversity and inclusion as well. So that it's it's important to realize that by using legitimate business factors, you're getting a broader picture of equity than just on pay. Pay equity audits also uncover any evidence of pay discrimination, for example, if there is average pay differences between Black and white workers after controlling for legitimate business factors. It looks for hotspots or clusters that can provide direction towards the root causes of those pay differences. For instance, are there commonalities of location, of position, of hiring cohort that align with a racial or gender disparity? Is the pay disparity as evident among recent hires as it is among retained employees? A pay equity audit can answer those questions for you. A pay equity audit also takes a multidimensional approach to remediation to tracking progress over time. The four main remediation elements that a pay equity audit includes are measuring the effectiveness of proposed pay adjustments, allowing you to do some modeling but for analyses, identifying pay disparity clusters that can eliminate root causes, flagging missing information related to legitimate business factors that could further explain compensation differences, and prioritizing those differences for disparate impact review. Finally, the degree of transparency that an employer provides regarding their pay equity audit is a separate choice. So conducting a pay equity audit does not obligate you to revealing that information when proper legal safeguards are maintained. Next slide, please. Right. So what are some of the pay, if you go down the route, and we recommend it obviously, to go down the route of conducting a pay equity audit, what are the best practices? Okay, there are 6 key elements. Identifying key participants, establishing privileged protocols, ensuring data quality, performing statistically sound assessment of your risks, and developing a multi-pronged mitigation response, and then ongoing monitoring of diversity, equity, and inclusion. You want to make sure that if you use an outside partner that they support all of these elements. Next slide, please. Okay, organizations should be proactive and get started now. And here's a quote from a former president. In any moment of decision, the best thing you can do is the right thing, the next best thing you can do is the wrong thing, and the worst thing you can do is nothing. And that's certainly true with these imminent reporting requirements coming down the pike. One sometimes encounters employers who think they are better off not knowing about what their pay differences are, but this is unlikely to be the case. It's up to the employer to respond to those results of a pay equity audit, and the degree to which the results of that audit are kept confidential are again within the employer's control. Employers should be actively engaged in the examination of equity and diversity before California regulators start asking for more information. Next slide, please. So Trusaic offers a PayParity DEI solution, which provides you with the insights you need to meet the challenges posed by California's new pay data reporting requirements. In addition to pay data reporting, PayParity DEI, diversity, equity, inclusion, alerts employers to pay equity, workforce diversity, and employee inclusion issues before being forced into defensive, reactive responses to California regulators. Through monthly monitoring, PayParity DEI goes beyond simple one-time measurements by tracking and identifying trends in these diversity, equity, and inclusion measures. PayParity DEI also provides you an assessment of underlying issues giving rise to DEI discrepancies, along with strategy, solutions, and advice for addressing those discrepancies. It combines the best, PayParity DEI combines the best of easy to use and interpret software and consultative solutions reflecting the 3 areas of expertise that are necessary: data cleaning, analytics, and regulatory expertise. With that, we're launching a participant poll question, which is, would you like a free demonstration of Trusaic's PayParity DEI monthly monitoring solution? With that, Nat, do we have time for any further questions?
Yes, Mark, I think we have time for maybe a couple more questions. Mark, do any other states have similar reporting requirements as California? And do you anticipate the return of the EO1 component 2 reporting from 2019?
California is a leader in this pay data reporting. We do see that it's being considered by other states, and on the component 2 EEO1 reporting. So what happened with that was that under the previous administration, they put some money into a study, a third study the value of pay data reporting. And so that's probably tied up for the rest of this year with that study by the third study by the National Academy of Sciences. But I think there's every indication that's going to be coming back.
Okay, and one last question probably. Would a company be penalized if they have employees paid differently who have the same experience, gender, and race, but who are working in different parts of the country? For example, what if your pay scale in California is a lot higher than what it might be in, say, Mississippi, for example?
Right. Well, to the extent that you're going to be reporting your Mississippi data, and we've sort of covered whether or not that would be part of your submission, the data is differentiated by location. So that's one of the factors that DFEH will be taking into account. So I don't think there would be a penalty for paying differences in different across different establishments with very different costs of living.
Thank you, Mark, for that great workshop. And thank you to our audience for attending today's workshop, California's new pay data reporting law and what you need to know before you file. We hope you enjoyed today's workshop. A follow-up email will be sent after today's presentation with Mark's contact information, the PowerPoint, and answers to all the questions asked by today's attendees. This concludes today's program. Enjoy the rest of the Hacking HR conference, and you may now disconnect.